mean, that clock is not in sync with that clock. Yeah. And that's supposed to be. This one's right now. Yeah.
Going to call to order the City Council's Net Housing Authority special meeting for this beautiful day, May 21st. Roll call.
Council Authority Member Taylor.
Here.
Council Authority Member Torres.
Here.
Council Authority Member Van. Here. Mayor Pro Tem Vice Chairperson Warren.
Here.
And Mayor Chairman Shaw.
Anybody wants to address this or submit some mail or would like to speak?
Mr. Mayor, we have none.
Okay, thank you. We're going to be moving into a closed session this time. Would you please make that announcement?
Thank you, Mayor and Council. The item for closed session is conference with legal counsel, existing litigation, one case pursuant to Government Code Section 54956.91. It's Tina Pacific Residents Association versus City of Stanton.
Thank you. I'll go ahead. We'll go into closed session. We'll be right back.
City Council is adjourned to closed session. We will reconvene once closed session has concluded. That will return then to the silence period.
Yes, very, very good. Okay, we're back, and what do we have to report out? City Attorney?
Thank you, Mayor and Council. There's nothing to report on.
Okay, thank you. Okay, I'd like to now come back into our regular scheduled special meeting. We need to go.
I'm sorry, sir.
We don't need to go.
Oh, we should now that we're back in regular
All
session.
right, go ahead. please.
Council Authority Member Taylor.
Here.
Council Authority Member Torres.
Here.
Council Authority Member Van. Here. Mayor Pro Tem Vice Chairperson Warren.
Here.
And Mayor Chairman Shaw.
We'll be adjourning, right? Go ahead, Gary.
I'm sorry. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we'll move on then to our first order of business, which is new business item 8A. This is considering the resolution of 202419 terminating the exclusive negotiating agreement with Brandywine Acquisition Group, CNC Development Company, and National Community Renaissance of California regarding a potential redevelopment project at the Tina Pacific neighborhood. Is there anyone who's asked to speak on this item?
Yes, Mr. Mayor, we do have one.
Okay, thank you. Okay, great.
Ms. Ugochi, we do ask that you please speak your name for the record, and then you do have 3 minutes.
Thank you. Good evening, Honorable Mayor, members of the City Council, Madam Clerk, and Council. My name is Ugochi Anabera Nicholson, and I'm an attorney with the Public Interest Law Project, one of the attorneys representing the Tina Pacific Association and the Kennedy Commission in current litigation against the City of Stanton regarding the redevelopment project in the Tina Pacific neighborhood. I am here regarding item 8A to comment specifically on the mischaracterization contained in this agenda item, proposed resolution, and ENA terminating language regarding our role in this matter. Contrary to what has been written in those documents, we are not blocking proposed development of this housing project. We are here to ensure the city legally complies with the redevelopment of the Tina Pacific neighborhood. We as the attorneys and the residents, we as the attorneys are not the plaintiffs in this action. We are not the roadblock to settlement. We have always been and are open to communicate with the city on how to resolve this case in a way that will ensure legal compliance with the state redevelopment and relocation laws, and that includes the replacement housing obligations. We believe that the city should not be using redevelopment funds earmarked for projects such as these to defend itself in lawsuits that come as a result of the city's own violations of law. Indeed, from the city's redevelopment reports on activities about its redevelopment projects, we understand that there's about $10 million available to the city that the city can and should be using to help the residents pursuant to Health and Safety Code, section 34176.2, subdivision A2. To our knowledge, the city has not been using these funds to help its residents. Residents do not oppose development. They simply want the city to comply with the law. Finally, abandoning the ENA will not absolve the city of its liability for its prior acts simply because it stops breaking the law today. We do remain open and willing to work with the city to protect the residents. Thank you.
Is there anyone else that is asked?
Mr. Mayor, we have none present.
Okay, I'll go ahead and close the public hearing at this time on this item and bring it back to your phone down. Go ahead.
Thank you, Mayor and Council. Item 8A relates to the proposed termination of the exclusive negotiating agreement regarding the potential redevelopment of the Tina Pacific neighborhood. The agreement is between the city and the residential developers, Brandywine Acquisitions Group, CNC Development Company, and National Community Renaissance of California. As background, the City and Housing Authority collectively own 31 parcels in a 40-parcel neighborhood known as the Tina Pacific neighborhood. The 10.27-acre site is bounded by Magnolia Avenue to the east, Cheryl Street to the west, an alleyway south of Pacific Avenue to the south, and Tina Way to the north. 9 of the parcels are under private ownership. The city began purchasing the properties a decade ago, around 2010, under the former redevelopment agency's jurisdiction. Before the state dissolved redevelopment agencies in 2012, those type of redevelopment agencies were authorized to revitalize blighted areas under their jurisdiction through specific statutory planning and funding. At that time, to this date, the city council has had a vision of eventually redeveloping the neighborhood. If and when it could acquire all of the parcels, raise money for design and construction of new housing, relocate tenants, all as required by law. However, shortly after the city's redevelopment agency began purchasing those properties, the state ordered cities to wind down those activities and dissolve those redevelopment agencies. That left many cities like Stanton with a shortfall in capital to reinvest into redevelopment. Thus, since 2010 to present, the city has served as a landlord to its tenants. Ollie Management Group is the city's property manager and oversees day-to-day maintenance and operations, such as rent collections and repair requests on the city's behalf. Rents collected from the units are reinvested into the city's properties. They pay for quality management's fees and they make improvements to those properties. Quality management responds to all requests for service. Because of redevelopment's dissolution, this city council and councils before it have have endeavored to explore partnerships with potential developers for this neighborhood's future redevelopment. At its October 27, 2020 meeting, the City Council and Housing Authority declared its 31 units as surplus under the State Surplus Land Act. That act governs the disposition of city surplus land, and the act's objective is to incentivize the creation of housing and or parks on state or city land. The city issued a notice of availability. The city received several offers to negotiate with developers, including the current developers. Brandywine, CNC, and National Core proposed 116 market rate units and 108 affordable units at this site. On December 14, 2021, the city agreed to negotiate with that trio of developers. I want to emphasize that in accepting the developer's offer to negotiate, it did not give the developers any legal rights to move forward with any project. Meaning, at the point of negotiation, every key term has been subject to negotiation. That includes how much the city would sell its 31 properties to the developer properties for, how many potential units could be constructed at that site, meaning this developer's proposal for how many units that it wanted to construct at the site was never accepted, and what potential housing would look like. There was no agreement on timing of development. It could have been years and years away. Essentially, through an exclusive negotiation agreement, nothing was agreed to except that for the negotiation period, the parties would try to negotiate toward a disposition and development agreement that would set those key terms. For the term of the negotiations, the parties agreed they would not negotiate with the other parties. To give the parties additional time, the negotiation agreement was extended several times and is currently set to expire in August of this year. 14 months ago, while the city and developers were negotiating in earnest, the Public Law Center sued the city, its Community Development Department, the city manager, and the Housing Authority. They also sued the 3 developers as real parties of interest. The PLC is suing on behalf of the Kennedy Commission and both named and unnamed parties. A central argument to the PLC's lawsuit is that because of the negotiation agreement, a project exists, and therefore the city must take other steps like adopt a relocation plan and a replacement housing plan. The city and Housing Authority fully disagree. The city's position is the city and developers are again only negotiating. There's no project that will displace tenants, and there's no need to replace housing because no project has been reached and certainly will not be reached under this exclusive negotiating agreement. Those obligations to adopt a relocation plan and a replacement housing plan would be required if the city and developers entered into a disposition and development agreement, agreed to a project, implemented it. But again, the city and developers were only in the negotiating phase. In this litigation, Housing Authority funds are being used to defend against this lawsuit. It's unclear if and when these issues will be resolved. The city, for these 14 months, has engaged in good faith negotiation with the PLC on potential resolutions, but litigation has only escalated. This runs up the Housing Authority's legal fees. Because of the expense and uncertainty of litigation, and because the Housing Authority must preserve its funds for continued maintenance, upkeep, and operations of its properties and tenants, the city and developers have agreed to terminate the ENA. This is a difficult decision for the city and Housing Authority, as this city council has expressed great hope for eventually constructing new housing at the site. The termination of this exclusive negotiation agreement means that negotiations will end between the city and developers. The proposed resolution directs the city manager to sign a termination agreement with the developers in a form acceptable to the city attorney. The resolution also directs that the city manager notify the state's Housing and Community Development Department that the ENA has been terminated and that no disposition acquisition and development agreement will be reached. With that, I'm available for any questions. Thank you.
Questions? Okay. So, we're here then to go ahead and approve resolution 2024-19. I will make the motion that we accept this resolution. Okay, roll call please.
A motion by Minister Chavez, second by Councilmember Taylor. I will now proceed with the roll call vote. Council Agency Member. Authority Member Van.
Yes.
Council Authority Member Torres.
Yes.
Council Authority Member Taylor.
Yes.
Mayor Pro Tem, Vice Chairperson Warren,
Yes.
and Mayor Chairman Chavez.
Yes, thank you. Is there any other business before us?
Mr. Mayor, we have none.
Thank you. Thank you, folks, for a special meeting.